party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of time. The arguments are being recorded. When you present your argument, please introduce yourself, stay behind the podium, keep your voice up. You should not use the names of children or minors or victims. You can use initials or terms like the child or children. We have read your briefs. We're ready to proceed when you are. And if you would like to sit at the table, you can. I want to make that available to you. If not, then I would just ask appellant, would you like to reserve time?
I would, Your Honor. Thank you.
Okay, how much?
5 minutes.
Very well, then we will proceed when you're ready.
Good morning, or good afternoon now, Your Honor. My name is Paul Grant, and I represent the appellant Antoinette Grant. First, I want to say I've had a cold and it's been difficult for me to speak lately, and I have a sore throat, so I hope I can speak loud enough for you. Your Honors, I am going to focus on our second assignment of error in this case, in that we believe the court erred in finding that the agency used reasonable efforts to reunify the appellant with her children. This case that we're here for the appeal involves 2 children, TR and MM, but there are 4 total children. These particular children are now 13 and 9. They're the middle children. This case began approximately mid-January of 2023, so 18 months ago. There was a video of my client having a physical altercation with her oldest daughter, who's age 8, she's now 15 years old. CSB did their analysis of the case, found my client had not gotten her children into school as they had moved from North Carolina to Ohio in approximately November 2022. She hadn't decided on where exactly she was going to stay. She allowed the children to stay with their respective fathers and family members. CSB initiated the case. They found emergency temporary custody on February the 7th, 2023. The case proceeded to adjudication on April the 10th, 2023, where dependency was stipulated to. Fathers received, at the disposition, temporary custody of the children, with the agency having protective supervision. A case plan went into effect. That case plan was filed on March 30th, 2023. Essentially, it had my client making sure that she had a safe and stable home and to seek mental health evaluation and follow its recommendations. My client actually engaged Portage Path a week before the case plan went into effect. So we're looking at a period from April of 2023 through August of 2023, about 4 months that she had to work her case plan. From the evidence presented at the legal custody hearing in August, she started the case plan early by going to Portage Path seeking counseling. There were some problems that caused there to be a delay in her counseling because the counselor had withdrawn and there wasn't a replacement for several months. But she didn't get 5 counseling sessions in, and the counselors indicate that she had made progress. She had been found to be diagnosed with adjustment disorder. Also during that time, she was able to seek and maintain employment. She found a house that was deemed to be appropriate, and she went above and beyond and sought anger management and Greenleaf in a parenting class. So she was doing a vast amount of work in a very short period of time before these motions were filed for the father of TR, Mr. Wrigley, to have custody, as well as Michael Mitchell to have custody of NM.
Did the fathers have a case plan as well?
Yes, they did. Theirs were to take care of the basic needs of the children. And I'm not going to argue about them not being appropriate at all. They took care of the child, their respective child, and allowed for visits, and took care of their basic needs. Children ultimately wanted to live with their fathers. So we're not trying to look at their analysis, we're looking at the analysis the court put on my client, which was very, very limited in time. And I think the basic argument that can be Mrs. Grant, in that she didn't have enough time to complete the case plan, especially mental health, is that she was in ongoing counseling. There's no deadline for that, but she had been making progress. But in July, less than a month before the trial for legal custody, it was recommended by the caseworker, Lucas Lewis Starks, that she have a parenting evaluation as well as a psychological evaluation. But no attempts were ever made to amend the case plan. Nothing was filed. It was discussed, and my client didn't agree with the assessment and wouldn't do it before she knew exactly what she needed to do. Her attorneys weren't able to look at that and be able to make decisions. So it was, in my opinion, the juvenile court magistrates and judge thought that that was a negative towards her not agreeing to get the assessments, whether it be psychological or parenting. And so with that, Your Honor, I think she wasn't perfect during the course of this case. There were still conflicts with the adult child. The other siblings got to see those conflicts, acknowledging that they shouldn't have happened. But when you have a 15-year-old young girl, now probably 14 at the time, you take her phone away, she's not going to like it, and it's going to be a problem. And she didn't initiate it. She was trying to parent. The child didn't take it well, and it caused a problem. And it did affect the children as far as having to see that type of situation happening in a visitation setting. So, Your Honor, I believe that that CSP did not follow through with their requirements to reunite this family, in that if they had concerns that the mother needed these assessments, they waited to the 11th hour. They didn't actually go through the court approval for that case plan objective. And the courts, I think, gave a negative approach to my client for not initiating it on herself. Although she didn't get any credit for doing the other things that were above and beyond that she tried to do to bridge the gap between her and her daughter, AJ. Certainly she recognizes that relationship had effect on the other children. But what is the rush? Why are we rushing to a judgment in this particular case only 6 months in, when the reunification plan and the case plan was to unify with my client? So with that, Your Honor, I would ask the court to reverse and remand this case to the juvenile court for further proceedings that found that the legal custody of these two children with their respective fathers. Thank you.
Thank you, Counselor. You'll have your full 5 minutes for rebuttal.
Thank you.
Good morning, Your Honors. Mary Hannah on behalf of Summit County Children's Services, who is the appellee. May it please the court? I don't have a whole lot to add to counsel's argument. It is true that the mother did, in fact, make some progress. That progress wasn't perfect, obviously. Nothing is. But her progress was stopped by her own actions. And it's apparent in reviewing the record that the mother had the belief or operated under the belief that she knew best. She knew best what was best for the children. She knew what was best for herself. And at some point she did stop her counseling with Portage Path. And there is reference in the record and in the court's order specifically, it said that she had decided she was going to self-engage for her own benefit and work on her relationship with God, which is great. However, it was not in keeping with the plan. And these children were desperately in need of permanency and stability. And there were 2 dads who were willing to do that, who did do that.
So when there is an adjudication of dependency, and the order says dependency and neglect, I don't know which one's right, I guess. Counsel said dependency, but in either event, isn't that a no-fault finding, the dependency, and it requires efforts on both parents' parts? So why do we have 2 fathers with no real case plan and a mother with a case plan? Why aren't they equally at fault for these kids not being enrolled in school, for example?
I think that the mother had removed the children to North Carolina, where they were residing for some time. When they came back, they did go to reside with the father, and there was some issue as to the father's actual ability to enroll the children in once that was resolved, the children were in school. And as far as the father's mental health, there were no questions, and as council conceded, the father's.
There are no questions about how involved were they with the kids before this case started. I mean, if they're not that involved, should there be some questions raised about their parenting ability?
Sure, questions raised about their parenting ability, but at that point, they were out of state. And we can't speak to that, that's not in the record. What I can direct the court's attention to is the fact that once they were within the father's care, custody, and control, the children began to thrive.
For the 4 months that they were there.
Correct. But again, this is not a situation, whereas recently, I know, Your Honor, you dissented in a case where there was a tumult. The situation, the relationships were not good. And that spilled over into the relationships for the children, with the father, and with visitation. This is not that situation. It does seem from this record that the father and the families have come together and created an area of well-being and safety. And the fathers are willing to work with the mother as far as visitation. There has been nothing in the record, or there's nothing that I'm aware of that said that the fathers were prohibiting the mother from visiting. This family has remained intact, and these efforts the Children's Services made in an effort to assist the mother to regain control of her anger issues and her mental issues. They did what they could, but it seems like there was a stopgap, there was a block, and the mother was refusing to acknowledge that she actually had a problem. She felt that she knew better, and unfortunately, the children are in a situation where they could have permanency, they could have stability, and now that is being shaken. That's threatened to be taken away from them because the mother felt that she didn't get enough time. And what we have here is a family that is intact, and reasonable efforts were made, and there is nothing, excuse me, arbitrary or capricious about the trial court's decision. Excuse me, I'm sorry. Apparently counsel infected me. So, what I would submit to you is that the court, its ruling, I'm going to rest on my brief at this point, unless the court has more questions.
No.
Thank you. I apologize.
Thank you for your presentation.
Well done, Ms. Manna. I would just like to add that this mother has taken care of her four children through the course of their lives, up until the last 18 months. She should be granted a lot of credit in labeling somebody with a mental health problem or adjustment disorder does not strip away all those years of success. And then to try to find additional answers through having a parenting assessment or a psychological evaluation at the last minute is not reasonable case planning. It wasn't reasonable and diligent. If they thought that mother was minimizing her mental health, they should have brought this up at the same time that they had the original case plan in March, or soon after. Why wait until the middle of summer on the eve of a legal custody case and then have that question mark about what those issues are? A major dark cloud over her head, and the unknown, to go before the court. And with that, I believe it's not a determination of the agency making reasonable case plan activities for her to be successful in having children return to her after they've been removed and satisfying whatever safety concerns there were. These children we're here for today did not have a relationship issue with their mom. That did not need to be worked on or cured. My client was going to continue to work on the issue with her older daughter and how that affected the family. But that was something that's going to be an ongoing thing, and maturity of this young lady is going to solve a lot of things else, as well as her learning how to deal with different things that come up with the young lady. Thank you.
thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of the decision to you on the day that it is released, and the opinions will be posted on the Ohio Supreme Court website. Thank you both again.